Today, we take for granted the idea a California company can do business with a customer in New York, or a Michigan factory can sell its products to a Florida buyer. We also take for granted the idea that state governments will not deliberately obstruct commerce originating from other states. But in early 19th century America, states could and did just that. My name is Matthew Collum, and here on Law and History, we're going to examine the landmark case of Gibbons v. Ogden. This case arose out of New York's Livingston-Fulton steamboat monopoly. That monopoly was an exercise of state power placing New York in direct conflict with the Commerce Clause. Let's take a look at this sequence of events and how the Supreme Court used them to clarify the Congress's ability to regulate commerce under the Constitution. In order to understand Gibbons v. Ogden, at least beyond a rote regurgitation of case law, requires the understanding of the history leading to the case. So let's take a look at it. America was founded, in historical terms, just prior to the Industrial Revolution. The technology, machines, and practices of that coming age were just beginning to enter American life. In the early 19th century, interstate travel in the United States, let alone the interstate transport of goods or passengers, was a tedious and often dangerous exercise. American roads were focused on local needs. They were often undermaintained and largely unsuitable for long-distance trade. The U.S., however, possessed an embarrassment of waterway riches. Much of the narrative of American settlement and expansion can be set against the banks of a navigable waterway, aiding large-scale commerce and migration. Think of the James, the Rappahannock, the Hudson, the Ohio. Think of the Mississippi, to say nothing of the abundant and accommodating bays and natural harbors all along America's eastern seaboard. As a consequence, most of America's traffic flowed on its waterways, both upon its rivers and along its coast, in the so-called coasting trade. In 1798, the New York legislature granted Robert Livingston the exclusive right to navigate its waters in exchange for his development of a steamboat ferry. Livingston was no ordinary businessman. He was among the nation's founders, sat on the committee that wrote the Declaration of Independence, administered President George Washington's oath of office, and served as Chancellor of New York for over 20 years. In 1807, Livingston partnered with Robert Fulton. The two men had met in France when Livingston was the U.S. ambassador there. Fulton, an American inventor and self-taught engineer living in Europe, had experimented with steam engines for several years. Ultimately, their efforts resulted in the successful launch of the North River steamboat, which was later renamed the Clermont. In reaction to their success, the New York legislature agreed to extend the monopoly it granted to Livingston, and now Fulton, for another 30 years. In 1809, Livingston and Fulton assigned to Livingston's brother, John R. Livingston, the right to operate steamboat traffic between New York City, New York, and Elizabethtown, New Jersey. In 1811, Aaron Ogden, a lawyer and former senator and governor of New Jersey, began operating a competing steam-based ferry service between New York and New Jersey. Ogden had unsuccessfully lobbied the New York legislature to break the Livingston-Fulton monopoly. But as the old saying goes, if you can't beat 'em, join 'em. And in 1815, Ogden purchased a license from John Livingston. This license, which required an annual payment of $600, permitted him to operate his steamboat ferry along his old route. Shortly after getting that license, Ogden partnered with Georgian transplant Thomas Gibbons. Gibbons was a minor politician, a wealthy planter, and an entrepreneur. But in 1817, the partnership soured. The two men split and went their separate ways. Gibbons, however, not ready to pack it in and call it a day, began operating a competing steamboat ferry service between Elizabethtown and New York City. Gibbons did not operate his ferry under a Livingston-Fulton license. Instead, he registered his vessels under the federal government's Coasting Act. In 1818, Ogden filed a complaint with the New York Court of Chancery. He sought a permanent injunction prohibiting Gibbons operating his Steudinger and Bologna steamboats in contravention of the rights granted by the New York legislature. Ogden was successful. Gibbons was now enjoined from running his ferry, and he was on the authorities' radar. Nevertheless, he instructed his business manager and ship pilot, Cornelius Vanderbilt, to keep sailing the ferry between New Jersey and Manhattan. Not being a man who knew how to lose, Gibbons appealed the injunction. He argued that New York's grant to Ogden of the monopoly regulating commerce between states and the injunction preventing his business's participation in interstate commerce violated the Coasting Act of 1793. In essence, Gibbon argued that the New York-backed monopoly ran afoul of the Supremacy Clause and usurped Congress's regulatory authority under the Commerce Clause. The issues decided in this case were straightforward. The court had to determine whether New York's legislation granting a monopoly on steamboat traffic in its waters to Livingston Fulton ran afoul of the 1793 Coasting Act. If it did, it would be in contravention of the Coasting Act and challenge Congress's power to regulate commerce under the Commerce Clause. Article 1, Section 8, Clause 3 contains the Commerce Clause. It states, quote, "The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes." These 21 words provided the broad outlines of Congress's regulatory power, but questions remained as to its extent and whether that power was exclusive to the Congress. So that's the setup. Let's take a look at how the court came to its conclusion. Unlike modern decisions, early SCOTUS opinions lacked the headings and uniform formatting that we find today. Nonetheless, we can separate this decision into two parts. Section 1 gave a full treatment of the Commerce Clause. It described what it entailed, its limits, and how it differed from other state powers like taxation or police powers. Section 2 explored New York's grant of monopoly to Livingston Fulton and whether it ran counter to the Coasting Act of 1793. Obviously, the Commerce Clause regulates commerce, but what did that entail? Answering that question centered on whether commerce encompassed navigation. After all, the New York legislation granted Ogden, quote, "the right to navigate the waters of New York." To answer that question, the court began its review with a textual analysis of the provision, which, to reiterate, expressly states that, quote, "Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes." Ogden's counsel argued commerce was limited to, quote, "traffic," to buying and selling or the interchange of commodities, but not to navigation. Marshall, responding to Ogden's argument, wrote that commerce is, quote, "traffic," but it is something more. It is intercourse. Commerce is regulated by prescribing rules for carrying on that intercourse, and the court could, quote, "scarcely conceive a system for regulating commerce which excluded all laws concerning navigation." To bring this home, the court expressly stated that, quote, "all America understands and has uniformly understood the word commerce to comprehend navigation." And with that, the court made it pretty clear that commerce and its regulation included navigation. For Marshall, this was axiomatic. The court reinforced this idea by undertaking a structural analysis of the Commerce Clause. It did that by examining Article 1, Section 9, Clause 6, which provides that, quote, "no preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another." The express provisions of the clause connected commercial regulation with ports and vessels, which are obviously places and instruments inextricably linked to navigation. Okay, so under both a textual and structural analysis, commerce includes navigation. But to what extent can this power be exercised? The court stated Congress's power to regulate commerce among the states did not stop at their borders. Instead, it emphasized the prominence of rivers in American commerce, stating that, quote, "the commerce of the United States is that of the whole United States. Every district has a right to participate in it. The deep streams which penetrate America in every direction pass through the interior of almost every state in the Union, and furnish the means of exercising this right." As this passage continued, the court began to show how it would apply this clarification of the Commerce Clause to New York's legislation. It continued, stating that, quote, "if Congress has the power to regulate commerce, that power must be exercised whenever the subject exists. If it exists within the states, if a foreign voyage may commence or terminate at a port within a state, then the power of Congress may be exercised within a state." In essence, if a waterway was navigable and could sustain commerce, then Congress had the right to regulate the commercial traffic sailing upon it. Not only could Congress regulate the channels of commerce, its right to do so was exclusive. To drive this point home, the court wrote that the, quote, "power to regulate is plenary. The power over commerce with foreign nations and among the several states is vested in Congress absolutely, as it would be in a single government. The court concluded its Section 1 arguments by writing that, quote, "The power of Congress comprehends navigation, within the limits of every state in the Union, so far as any navigation may be in any manner connected with commerce with foreign nations, or among the several states, or with the Indian tribes." So that seems straightforward. But could Congress's right to regulate commerce be exercised in concert with state governments, as Ogden's counselors had argued? Ogden's counselors argued that the 10th Amendment permitted state governments to regulate commerce concurrently with the Congress. Conversely, Gibbons' team argued that, quote, "Full power to regulate a particular subject implied the whole power and left no residuum." The court summarized the issue in this way, quote, "The sole question was, could a state regulate commerce with foreign nations and among the states while Congress is regulating it?" Ogden's counsel, in support of his argument, provided several examples of state action affecting commerce. These examples were purported to do so in tandem with the federal government. For example, he argued that Article 1, Section 9's limitations, quote, "prohibiting the states from laying duties on imports or exports," proved the existence of the state's authority to regulate commerce. The court, however, reasoned that this power was not a regulation of commerce, but was a, quote, "restriction on the taxing power retained by the states." Other examples included inspection laws, quarantine laws, ship pilot regulations, and even lighthouse construction. However, the court reasoned that these acts did not evidence the states exercising concurrent authority in commerce regulation. Instead, these were examples of state police powers. The 10th Amendment reserved to the states their police powers to regulate the health and safety of their citizens. But these powers did not permit states to regulate interstate commerce. As you can probably tell, this line of argument did not sway the court in Ogden's favor. Despite Marshall's clear argument and its conclusion, he continued. It appears he wanted to address and end any arguments granting or purporting to grant to the states the ability to regulate commerce alongside Congress. Now that the Commerce Clause had been defined, its powers elaborated and explained, Marshall would apply it to New York's legislation. The court turned to the question of, quote, whether the laws of New York, that is the Livingston-Fulton monopoly, collided with the 1793 Coasting Act, thus depriving Gibbons of a right to which the act entitled him. The answer turned on Article 6, Clause 2, the Supremacy Clause, and whether New York's grant of monopoly interfered with the 1793 Coasting Act. The court noted that any state passing legislation interfering, quote, with or contrary to the laws of Congress made in pursuance of the Constitution, that in every such case, the act of Congress is supreme and the law of the state must yield to it. Ogden's counsel argued that the 1793 Act only regulated the pre-existing right to engage in commerce, and to an extent this was true. The Constitution itself did not create a right to engage in commerce. The right was merely recognized by it and provided Congress the ability to regulate it. And to that end, the court wrote that the act was simply a regulation of commerce, but that it implied, quote, unequivocally, an authority to license vessels to carry on the coasting trade. Marshall then examined specific parts of the 1793 Act, but frankly, recounting them here is to beat a dead horse. The New York Act regulated commerce across state borders. This was in contravention to Congress's exclusive ability to do just that, and as a consequence, it was invalid. The court concluded its arguments with its holding. It wrote, in pertinent part, that, quote, this court is of the opinion that the several licenses to the steamboats, the Stutager, and the Bologna to carry on the coasting trade gave full authority to the vessels to navigate the waters of the United States for the purpose of carrying on the coasting trade, any law of the state of New York notwithstanding. In short, the 1793 Coasting Act, by virtue of Congress's exclusive right to regulate interstate commerce via the Commerce Clause, and of the Act's superior weight via the Supremacy Clause, voided New York's grant of monopoly to Livingston Fuller and to their heirs and assigns. Associate Justice William Johnson authored a concurrence mirroring Marshall's holding, but he did so with a slightly different argument. That argument was more straightforward and to the point. It avoided Marshall's oblique tact. In essence, the power to regulate commerce was exclusive to the federal government, and any state laws to the contrary were void. He wrote rather succinctly that, quote, the power of a sovereign state over commerce amounts to nothing more than a power to limit and restrain it at its pleasure. And since the power to prescribe the limits to its freedom necessarily implies the power to determine who shall remain unrestrained, it follows that the power must be exclusive. It can reside but in one potentate, and hence the grant of this power carries with it the whole subject, leaving nothing for the state to act upon. I won't elaborate upon its concurrence any further, but if you are curious, you can read it in the link below. The effects of this decision went far beyond the termination of the Livingston-Fulton monopoly. New York City, already a commercial center, exploded into an economic powerhouse as its waters were no longer a barrier to trade, investment, and efficient capital flows. New England's nascent coal industry grew quickly as increased steamboat traffic drove demand. This would also help set the stage for the growth of the railways that would, even more than America's rivers, knit the vast country into a single, coherent marketplace. An interesting aside to this story involves Thomas Gibbons' business manager and the effect the court's decision no doubt had on his success. As you'll recall, the man's name was Cornelius Vanderbilt. A self-made man, he worked for Gibbons to learn the steamboat trade. After the events of Gibbons, he would form his own steamboat company and shipping business, before eventually converting the capital obtained there into his own railway business. He was often called the first tycoon, and his transportation empire was no doubt aided by the Gibbons decision. Of course, Gibbons v. Ogden was decided over 200 years ago, and the court's jurisprudence regarding the Commerce Clause has evolved with the nation's historical experience. While a detailed explanation of just how the court's views have evolved is beyond the scope of this video, let it suffice to say that it has. Congress can regulate the channels of commerce, the instrumentalities attendant to it, and even intrastate activities affecting interstate commerce. It has spoken at length regarding the dormant Commerce Clause, but these are topics for another day. Nevertheless, Gibbons v. Ogden laid the foundation for the court's jurisprudence in this area of law, and that's why you need to know about it. If you made it this far, thank you. Give the video a like, leave a comment, and subscribe to the channel. Be sure to check back often and for more content. Have a good day.